Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us. Today we're going to be talking about wills and estates. And who better than to talk about this? My co-host is always Jesse. How you doing, sir?
I'm doing great, Dave. How about yourself?
Okay, Jesse Barrientes, what's new?
Boy, well, we're trying to get in the summer here, but slowly getting. Just want to hit some golf balls, but it's been raining every day, every other day.
At
So
least we're hanging in there.
that's true.
Listen, on that topic, we're talking about something that's a little bit
Right.
morbid. We're talking about wills and estates and planning for things that might eventually happen or not, depending on your circumstances. And it's really important to have things in place or to have an idea of who you want to carry on your desires after you leave. So touch base on how this should get started.
Well, everybody should have some type of an estate plan. It doesn't matter if some people think that, it's just for people who have a lot of assets and everything else. And I mean, that's true too. But you want people to know your wishes as it relates to health care, as it relates to other things as you age, or, emergencies happen, things happen nowadays. Nobody, the next moment is not guaranteed. And so it's important to be on the same page. And people always neglect that, even though it really is important kind of a thing to have.
What are the type of items that we want to have in place?
Well, some of the basic things. There's a basic will. There is, and we'll talk about these things in turn. There is a living will. There is a durable power of attorney for health care, power of attorney for property, and there's, of course, a DNR, if that's what you want, do not resuscitate. You could also do a trust. There are ways to avoid trusts and or ways to avoid probate with other vehicles and stuff that we're going to talk about.
Well, obviously your family dynamic is going to dictate the types of documents that you need, whether you need to appoint guardians and things like that.
Absolutely.
If you have minor children, or if there's property that's jointly owned, business property. There's just a lot of complications in this. But let's start with something simple. Let's take an individual who may be married, doesn't have a lot in the way of property, but wants to make sure that spouse is protected.
Generally, the spouse is going to be protected. Usually people have, maybe not so usually. I've come across a lot of situations where people have their own separate accounts, but if it's a case where people have a joint account, generally accounts like that are set up with what they call right of survivorship, which means that if anything happens to the other spouse, and it doesn't have to be a spouse, you could set that up with an elder parent or with anybody else, then those funds automatically pass to you outside of probate. And we're going to talk about that in just a little bit. Probate kind of gets to be expensive. So let's talk first about maybe just having a will.
Right.
People who die with a will or die without a will, testate or intestate. If you pass away without a will and you don't have things that perhaps pass outside of probate, like, for example, classic example would be a house. If parties are married, there's different ways to convey property or to own it, to title it. If you're married, generally it's tenancy by the entirety, which is a form of joint tenancy, but it protects the spouse from any creditors that the other spouse might have, so they can't get that person's share. So you're an owner of the undivided whole. Joint tenancy is similar, but you don't have that protection that you would with tenancy by the entirety. So joint tenancy would be, for example, if you weren't married, if you're going to get married at some point, but you're buying a house together, or maybe you bought a house with one of your friends. You're just trying to build some equity and just chill out for a while. That could happen that way too.
Okay, so if it's joint tenancy.
If it's joint tenancy, and again, it has to be set up, and the same is true with a bank account, again, with right of survivorship. So if anything happens to the other person, then the property passes outside of probate. There's no need to go to court, and it passes to the joint tenant.
Same thing with a bank account, with a retirement account that's set up that way.
Well, with the retirement account, it's a little bit different. You can have your beneficiaries that it passes directly. So let's talk a little bit more about probate initially so that we can kind of address what that is. So what is probate? All right, so if you die without a will and there's property and there's things that are unresolved and things that haven't passed outside of probate, then you have to file an estate, okay? You have to open up an estate. And generally that has to be open. It's probably going to be open for at least over a year, because there is a 6-month requirement when you file it, if for creditors, to people to get notice, and you have to do publication, everything else. So that's going to be open for a while. But that's expensive. You got to go to court. You got to get a bond if it's not provided for in a will, if you don't have a will. And again, it's intestate. There's a whole statute of descent that says where the property goes if it's not otherwise disposed of, to your spouse, to your children, to your siblings, to your parents, and everything else. But it's important that, hey, if you want, you've earned the stuff, you've worked hard for it, you want to, where you want it to go. So if you have your will, generally the will allow for the disposition of all of your property. And you generally, in a will, you have provisions that, for example, you're of sound mind, Dave, nobody's coercing you into this, and that you're revoking all of any previously wills or codicils. A codicil is an instrument that kind of amends a will without redoing the will. I just like to redo the whole thing just to keep everything all neat and tidy. And so that's what kind of what that does. And you also get into who you want your property to go to. Let's take in your example. You would leave everything to your spouse, even though, for example, the house, that's outside of probate. You don't have to worry about that. But you would have it in there. Let's say perhaps that you have children. And so a lot of times what people do is a crisscross will. So it's the same will for the husband and the wife. It says exactly the same thing, so that it goes the same place. But there's also a provision in there that says that if the parties die in a circumstance, let's say the husband and wife were in a car and there was a car accident, and it's impossible to determine who passed first. So in one of those crisscross wills, all right, it will say that, hey, if anything happens to me where it's impossible to determine who perished first, then I will be the one, will say that it was me. And then the other spouse's will say the opposite. And the reason for that is so you avoid having a double probate, okay? So that's a very important thing. The other important thing to know, too, is generally if you have this crisscross will, if anything happens to the other one, it's pretty much got to kind of stay the same. Another provision you want to do is if you have young minor children. I mean, where do you want the children to go? I mean, you can have a say-so that there's no guarantee that that's going to happen. I mean, is it paternal grandparents, maternal grandparents? Is it somebody else?
You're talking about naming a guardian until the child or children are of legal age?
Right, or whatever age you want.
This may or may not be the same person as the executor of the will, correct?
That's correct. It doesn't have to be the same person. And then that person is the one that's going to be responsible. There's just a lot of issues when it comes to fraud and things like that, where somebody's the trustee and they're spending money, and you see that a lot with guardianships, with especially with elder people, where they're getting their money and it's not being appropriately spent. But the court does require that a report, an annual report, be filed.
What if the surviving spouse just takes over the estate and doesn't bother with probate and just goes on their merry way?
The surviving spouse, true. I mean, if you have the surviving spouse, there's no need for the guardianship. But again, you still have the will crisscross. Yours was the same as your spouse's. So if anything happens to her after you perish, you still have that. Or she might want to update that depending upon what happens. Maybe down the line she gets remarried or something. Okay. But it's just important to have that in there. And again, if your other spouse survives you, and again, the kind of example we're talking about, if both people, something happened to you, a lot of times you go on a vacation, you both decide to do cliff diving. Okay, I don't know if that's a good idea. It's certainly not for me. But you just want to be protected. At least it gives you some kind of a peace of mind.
You just never know what will happen.
That's correct.
I know someone just recently who went on a Alaskan cruise as a gift. He said it was too long, but whatever. There was a ship following them. And that
pirate ship.
Not quite. But someone on the ship following behind them, going through the same tour, did an excursion on the helicopters. And they just recently perished in that excursion off the ship.
Off of the ship, off the cruise.
So you just never know. I mean, you're going on a cruise ship, and maybe someone says, hey, it would be interesting to do this excursion, highly dangerous, and they perish. So who knows if they were prepared for with an estate plan, if they had minor children, who knows. But let's talk about divorce, though. Let's say you got a will in place, and then you get divorced. Do the terms of that will still maintain effectiveness?
Well, generally, in the divorce decree, there is a complete and utter waiver of any right for somebody to be the executor. And again, I want to go through some of these terms too.
Yeah.
I think we'll have time.
Important exception.
Important exception. An executor is somebody who's the one who's going to be responsible for kind of taking care and winding up your affairs after something's happened to you. So that generally, typically, it's the your spouse. If not, then you have what you call successor executors, that if that person doesn't want to, or if they predecease you, there's somebody else that's in there to step in.
And you hope they do that fairly and quickly.
You hope they do that fairly and quickly. And then again, in the will, generally you want to waive the bond, because if you don't have a provision for waiving the bond, the judge is going to make you get a bond that's worth at least 1.5 times the estate. And so that's going to cost money to get that bond. And that's to provide or to prevent any type of fraud that might happen, or, in terms of the creditors and things like that, of that nature. So that is very important. But in a divorce, once you get divorced, and that's a good point, Dave, because a lot of people, once they do the divorce and everything, that's it. They they move on to something else, they forget about it, and they still leave it in there, and people may not know about it. So that's kind of some of the things that you want to do after.
Well, the will, I think, is
divorce.
void as to the divorcing spouse. However, there's that one exception that I wanted to mention to you. If they leave a retirement account with the former spouse as the beneficiary, and they don't change it, I don't believe it matters what the divorce decree says. If they don't change that beneficiary, the divorced spouse, surviving spouse, will still inherit off that retirement account, even though they're divorced.
Right, and that's called a quadro, Qualified Domestic Relations Order, or quildro, for Illinois, Qualified Illinois Domestic Relations Order. And it's a special order that has to be sent to the plan administrator and approved, and then entered by the court, and then a certified copy has to be sent to the plan administrator, and then it gets segregated. But if that doesn't happen, I'm talking
about a beneficiary designation.
Well, no, if the ex-spouse doesn't do that, even though it's provided for, and then the person gets married and something else happens to him or to her, then it's going to go to their new spouse, and so they're going to be out of luck. But let's get back.
Same thing with life insurance. You got to change that.
Well, you got to change it, even though in the divorce decree, generally, that's what it says, that you forfeit your right to be the executor. You forfeit your right to collect on any insurance. Now,
but if it's not changed,
exception.
it's deemed that they left it in there on purpose.
Well, no. If it's no. If it's in the divorce decree, they're going to have a problem with that, and then this is something that's going to be litigated then in probate court. But so basically, that is it. So it's in there. It says that you forfeit it. There's an exception though, because in Illinois, you can have insurance to secure maintenance payments. So if somebody's required to make maintenance payments, and there's an insurance policy to provide for that, whatever the amount of that is. So generally, the divorce decree will state that, all the other insurance policies, the other spouse waives it, with the exception of this, because that's specifically intended to provide for that. Well, let's get back to more of the estate stuff. So we've talked about the will, some of the provisions in the will, having the guardianship provisions in the will. Let's talk about the execution of the will. So it's very, very important. A lot of people, I know Illinois only requires to have 2 competent witnesses, and by competent, you have to be over 18. You can't have anything that would make you declare you incompetent. Really shouldn't be anybody who's inheriting under the will. Should be somebody who's completely separate and apart. Now, generally, I do 3 witnesses, just in case there's a problem with one of them. You got the extra one. Now, whenever you do sign the will and you go hopefully to your attorney's office, everybody has to watch everybody. So you need a notary. So the attorney generally will kind of explain the will, go through the provisions just kind of generally. He or she will have gone through that with them before, and so everybody knows, hey, listen, this person, they're not intoxicated, they're not loopy, they're in their right frame of mind, they're not doing it being coerced, nobody's got a gun to their head to make them sign off anything. And then they initial the pages, they sign it, and the witnesses and the notary has to watch the person sign it, and they have to watch each other sign it.
Can the notary be the same person who prepared it?
The notary could be the attorney, yeah,
Okay.
and we try not to do that, but it certainly can be the same person. A notary can notarize any signature except his or her own. So, but again, that's very important. A lot of times attorneys, they don't pay attention, but it's very important because if you ever go to have litigation on that, then they might ask you, and so I always try to do things, over and above what we can do. So that's signing that. Let's talk about some other documents that are also important for estate planning, and we'll hopefully we have time to just to touch on the trusts and some of these other things. But generally, when you do a will, you also have a living will and a durable power of attorney for health care. There's some other documents we're going to talk about too. A living will basically is saying it's like the durable power of attorney for health care. The durable power of attorney for health care basically says, hey, listen, if something happens to me, I want I want the doctors to use every effort on me, no matter what, okay, to revive me, to do whatever. I want the best care I could possibly get. Or, if they don't think things are going so good, then, hey, I don't want them to do anything, and I'm designating somebody and a successor person to make that decision. Right.
If you become incapacitated where you can't make it on your own.
That is correct.
Up until that point, you're making your own health decisions. It's just if you become incapacitated.
Right. And the living will basically mirrors that. So it says that, hey, this is my this is what I want. And so the durable power of attorney for health care only comes into place when, if I'm incapacitated and I can't make that. But generally, somebody's at the end of their life and, or they have cancer, they have some other disease, and they're really not of the right frame, because they're on all the medication or maybe some painkillers or whatever it is. So that's true. The other thing is a power of attorney for property. And so that allows somebody to do whatever you could do in your place instead.
Let's talk about those things that they can do.
So let's just take a side note here and say, okay, so, I do real estate as well. So let's say, Dave, you're selling your house, and you know what? You're going to be in the Bahamas on the day that we have the closing, and hey, you just, I have you pre-sign everything I can have you pre-sign, but at the closing we might need to make adjustments.
This is certainly fiction.
Certainly, for you, Dave, it might be certainly fiction. But we'll have you sign off on the power of attorney, and we'll strike everything else, and it will be very specific and say, hey, listen, I can do anything to affect the sale of whatever this real estate is, okay, to signing documents. And then even though I'll have you pre-sign everything else, at the closing, I'll sign as your power of attorney. All right. Now, generally people have power of attorney, again, if they become incapacitated. A lot of times it's, elderly parent, but it doesn't have to be. It could be you or your spouse, and so it's important to have something like that. And you have successor people. So generally the person you want is, perhaps your spouse. And that's another thing you want to change if you get divorced, for sure. But I believe the law says if that's the case, the power of attorney, it's done.
Okay.
By operational law.
Right.
So I can do anything that you could do. So you know what? If I have your power of attorney, Dave, I could sell your house. Now, of course, if I did it without, and basically you're the principal and I'm the agent. If I did that, I might be in trouble because I'm supposed to follow your directions. But
you could sell property,
I could do that.
You could pay taxes.
I have authority to. I could do anything
that the
right.
person
Anything
could
that
do,
you
the
could
power of
do.
attorney could do.
Exactly correct. Okay. And the important thing to note again, a power of attorney could become effective for a specific duration of time, like I told you in the example with the real estate. So okay, it's and generally we do like maybe a week, because sometimes a closing might get pushed. So we'll have it, and then after that it automatically terminates, or it will come into effect on my incapacitation as determined by my physician, by a doctor that says, hey, you're incapacitated. And then that person could now make the decisions, pay, again, your taxes, pay the mortgage, or even sell the house if need be to get you into a home, or
liquidate
to do whatever.
property.
Liquidate property and do all those other things. And it's important to keep, records, again, to stay above reproach so that there's no allegation or implication of fraud or anything like that. But the power of attorney for property terminates upon somebody's death. Okay? And so once that happens, it's no longer good. So we've talked about the will. We've talked about the living will, the durable power of attorney for health care, and the power of attorney for property. So let's talk about, just to touch on perhaps a trust. Are you familiar with trust, Dave?
To a certain extent. It's not my area of practice, but
Okay. So basically, a trust is a private contract, and so it stays out of probate. All this other stuff that I was talking about, when you have the will, okay, if property doesn't otherwise pass, you have to file that probate estate. Okay, you have to file it. Okay, petition for probate for letters to basically get letters of office so that you could do it and handle all the other kind of things legally. I mean, even though you have the power of attorney, okay, that'll work until if somebody passes away, then that's it. And if you don't have anything else in place, then that's the only way to do it, to be able to liquidate everything. All right. So a trust is a private contract, all right, and so basically everything would go outside of probate. So I would designate in my trust, just like I would in my will, that okay, so I'm the trustee as long as I'm around and I'm good and everything else. I'm the trustee. My wife, my spouse would be the successor trustee. I might have, my son Dave as the first successor and second successor. You could go through the line who you want, because sometimes people don't want to have any part of it and everything else. But it sets out specifically what I want. Now, maybe, I don't want to give you, I don't want to divide all the money evenly. I want to just give it a little bit. Or maybe, one of my kids is a spendthrift, or one of my people that I'm leaving money is a spendthrift. And, I just want to provide so much a year or a
Right.
month to be able to do that. But the trustee is going to have the power to determine whatever. Again, trusts are limited only by your imagination. But everything goes outside of probate, so you don't have to go into court to do that. Now, do people get dragged into court for those things? Yeah, because people believe, oh, no, they're not doing it. They won't give me a copy of it. And there's just all different kind of things. That's kind of beyond our program here today.
who manages the trust? Don't you pay an agency to manage that trust and to hold it?
You could, or it could just simply be, again, if it was for property, yeah. But here's the other thing, what I was getting to. You have to fund the trust. So if we have the Dave Siegel Trust, okay, well, now all of your property has to be put into that trust, Dave Siegel Trust. So your real estate, your bank account, your car, everything. So that's why also in that situation we also have what they call a pour-over will. And that is because there's inevitably going to be something that you didn't put in the trust. Maybe it's something that you just bought. Didn't have time to put it in the trust and something happens. So you have that kind of pour-over will just in case. But that avoids the whole deal of probate. A lot of people have said, oh, I don't want to do anything complicated. I don't want to do that. And, it costs a little bit more, or perhaps, to have that prepared. But, you're taking care of it now, so you don't have to worry in the future to take care of it, right?
Right.
So
So if you're constantly acquiring property, changing vehicles, if you're still relatively young, then is that a good idea to have this living will?
It doesn't matter how old you are, how young you are, how fat you are, how tall you are, how fit you are, how sick you are. The next moment, Dave, is not guaranteed for any of us. And you go outside and something could happen. It doesn't matter if you're young. I mean, that's just how it is. So it's important for everybody.
But you have to
stay on
keep
top of
revising it with all the property that you acquired over your lifetime to put it in the trust.
You just have to fund the trust, right? You have to put it in the name of the trust. So some people don't want to do that. Just want something simple. They just want the will. They just want the living will. They just want the durable power of attorney for health care. They just want the power of attorney. Okay. And then so sometimes we can take care of that, okay? Because, all right, your spouse, okay, you're on again, on the house, no problem. Tenants by the entirety, it passes. Joint accounts, you're on the account, it passes to you. The retirement accounts or the beneficiary for the life insurance, you're designated it, all passes outside of probate, all right? So let's just say that, all right, this happens, but now your spouse passes. Okay, so there is an affidavit of survivorship that generally you could file with the recorder's office, and it's good just to get it done so that it's already in file and with the copy of the death certificate so that they know, and that's a matter of title. Now, in order to avoid probate, so I could put my son now, okay, something happened to my spouse, I want my son, I only have a son, I want him to be on the property, but if I do that, now, the only thing I could do is joint tenants, and hey, if he has creditors, they can attack the house, and I'm not going to, I don't want to do that. So
Right.
they have a TOD, transfer on death deed, okay? And so it's relatively new, I think within the past few years or so. So that allows somebody to designate who they want to have that real estate to pass outside of probate without having that person during your lifetime be a joint tenant or having any interest in the property. And so what happens is it gets completed, and you list who your designated beneficiaries. There could just be one, there could be a couple, however you want it. But then it also has to be filed and recorded with the recorder of deed during your lifetime. And then basically what happens is after your death, they have to provide proof of that. And then what happens is the property now then passes to those designated beneficiaries outside of probate and not having to worry about those expenses. And again, that's if you don't have a trust. Again, I don't know, some people have said, oh, it's too complicated. And I guess I can understand that. Oh, you got to fund the trust and everything else. So in some of those situations, it might be important, to be able to have that again, because you don't want to spend any more money. You've already worked for that. You already paid your taxes and everything on it, and you want it to go where you want it to go.
Let's talk about a will where one of the spouses renounces the will.
Well, you can renounce the will, for sure, and I guess there are different reasons to renounce the will. Or let's say, how about a situation where, you know what, I have a will, I've been married all this time, and I die, and lo and behold, my spouse finds out that I left everything to my girlfriend. Oh my gosh, right, Dave? Right? So it's like, heck no, that's not going to happen. So what could happen is, again, the spouse would get the spousal 2/3. And that's how that works. But, I suppose you could renounce a will. Let's say that if I inherited whatever you're giving to me, that it's going to put me through a certain tax bracket or loop, or going to cause those complications that is going to cause more liability than the asset you're trying to give. Then it can certainly be renounced. But that has to also be done in writing.
Okay, we just got a minute or two left. A couple other important topics that you'd like to discuss.
Well, yeah, I think it's very important for everybody to have some kind of estate. At the very least, you want to at least have a will. And by the way, if somebody passes, you have to file that will within 30 days with the clerk's office in the county in which you reside. And that's whether or not anything's going to be filed or probated or not. Okay, so it's a requirement. It has to happen. So it doesn't mean that something's going to be probated, but you have to kind of do that. All right.
If you have a will.
If you have a will. It's a good idea to have it, and especially if you have young kids and you want to have an idea or at least some kind of a say-so where who you want the guardian to be. That doesn't mean really that's going to happen. There's so many complications going to happen after that, but at least you have a say-so, and generally the courts try to make that happen as long as that's going to be in the best interest of the
and I think with all the complications, it's not a wise idea to try and do this alone.
No, they have a lot of products on you could buy and to do that yourself. It's just like anything else. I'm not going to try to put in my electrical box in the basement because I'm not an electrician. Could I figure it out? Oh, maybe I could look at some YouTube and hope that everything goes well. Yeah. But you really need to go to an attorney who does that kind of work and who's going to do it. Because again, remember I told you about simply just executing the will. All right, you have to do that in the appropriate way. You have to have the appropriate number of witnesses and everything else. And it's very important. And again, each of these things are important based upon your unique situation and your assets. And so you need to get a lawyer. You don't need to get one of these forms.
Yeah, and of course safeguard these documents.
Exactly right.
Great information, Jesse.
All right, Dave.
On wills and estates. We'll see you next time on Legal Action. Take care.